A viral Supreme Court headline is making gun owners think public carry rules just changed everywhere at once. But if you trust that headline without knowing the details, you could walk into a criminal charge while believing you did everything right. Quick question before we continue. Are you subscribed? Because what I'm about to explain could save you from making a mistake that follows you for years. Hit that button now, because gun laws move fast, and confusion is exactly where people get burned. Here's what just happened, and here's the first thing you need to know. The Supreme Court did not wave a magic wand and erase every carry permit rule in America overnight. That did not happen. There was no nationwide order saying permits are dead. There was no one-line command that suddenly made every state a permitless carry state. And that matters, because a lot of people are hearing one dramatic sentence online and filling in the blanks with hope. The real fight is narrower, but still huge. It's about what happens after you already have a carry permit. In plain English, the question is this. If you are legally licensed to carry, can a state still make huge parts of daily life off limits? By saying you cannot carry on private property that is open to the public unless the owner gives clear permission first? Think about that for a second. That means stores, restaurants, gas stations, parking lots, banks, and other everyday places. Now, this is where it gets interesting. The Supreme Court already ruled in Bruen back in 2022 that the Second Amendment protects carrying a handgun outside the home for self-defense. That was a major win for carry rights. The court struck down New York's old rule that made regular people prove some special need before getting a permit. In simple terms, the court said the government cannot treat your right to bear arms like a favor reserved for a tiny group with the right story. But here's the crazy part. Bruen answered one giant question and left several smaller questions behind. The court made clear that states can still have objective permit systems. That means things like background checks, fingerprinting training, and other basic rules that do not depend on an official liking you or believing your reason is special enough. The court also said some places can still be restricted. These are often called sensitive places. Courthouses are the classic example. Schools and government buildings are usually part of that conversation too. And that is exactly where the confusion exploded. After Bruen, some states did not simply accept the ruling and move on. Instead, they rewrote their carry laws, they expanded lists of restricted places, they created new location rules. And in some states, lawmakers tried something many gun owners saw as an end run around Bruen. They said private property open to the public would be a no-carry zone by default, unless the owner gave express permission. Let me break that down for you in normal language. Under that kind of rule, silence means no. If a store owner says nothing, you cannot carry there. If there is no sign, you still might be breaking the law. If the place is open to the public but privately owned, the state treats it as off-limits unless permission is clearly given. That is why so many people call this the vampire rule. Just like in old stories, where the vampire has to be invited in, the carry holder has to be invited in too. Second, you need to understand why this matters so much in real life. Most people do not spend their day moving between courthouse steps and police stations. They go to normal places, they stop for coffee, they get gas, they walk into a pharmacy, they pick up takeout, they meet family at a diner. If the law says those places are off limits unless the owner gives express consent, then a person with a valid permit can leave the house legal and become illegal the minute daily life starts. Here's a hypothetical example to explain this. Imagine you have a valid carry permit. You leave home, drive to work, stop at a convenience store, and walk in to buy a drink. There is no no-gun sign. There's also no sign saying carry is allowed. In some states, under these post-Bruen laws, that silence could become the trap. You thought your permit protected you. The state says it didn't because you lacked express permission. That is the kind of confusion now sitting in front of the Supreme Court. And one more thing most people get wrong. When they hear emergency ruling, they assume the Supreme Court made a final decision on the actual issue. Not always. The court's emergency docket is the fast lane. It handles urgent requests. Sometimes the court steps in, sometimes it refuses, and sometimes a denial means almost nothing about who will win later. That already happened in the New York litigation. In an earlier emergency request tied to Antonyuk, the Supreme Court refused to jump in right away. But the justices did not say New York's law was fine. They simply let the lower court process continue. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you when cops ask about your gun. Subscribe so you don't miss it. Now let's get to the part nobody's talking about clearly enough. The current nationwide confusion exists because different courts are looking at very similar carry restrictions and reaching different answers. That is a huge deal. When federal appeals courts split, regular people pay the price first. One state tells permit holders, you are good unless the owner says no. Another says, you are not good unless the owner says yes. Same country, same constitution. Totally different daily risk. The Hawaii case is the one sitting front and center. The Supreme Court agreed to hear Wolford v. Lopez, and the justices heard arguments in January 2026. The big question is whether Hawaii can presume that private property open to the public is off limits to licensed carriers unless the owner gives express permission. That sounds technical, but it is really a street-level question. Can you carry into ordinary businesses unless posted otherwise, or does the law flip the default rule against you? Supporters of the Hawaii law say the state is protecting property rights. Their basic point is simple. A private owner should control the property. If you want to bring a gun onto someone else's land or business, the owner should get to decide. They say the state is just making that rule clear. Opponents say that sounds neat on paper, but in the real world, it guts public carry almost everywhere that matters. Why? Because most places you visit are private property open to the public. So if the default becomes no carry unless invited, your permit starts looking less like a right.